it back going, so you can all just find your spots. That'd be great. Well, we've had a great morning and wonderful panelists, and we are very excited about what the afternoon has to offer. And I'm sure we will be just as enthralled with what we're hearing this afternoon. I'd like to remind everyone that we will be doing cards for your questions. They'll be going around. So please, as you hear panelists speaking and you have questions, please fill out a card that with your question, and then we will pick them up and we will ask those questions after our panelists are on. And also as a reminder, we're not actually going to give introductions. There are biographies of all our distinguished panelists and moderators within the program, so please familiarize yourselves with that. We are looking forward to this afternoon, and again, Mr. Joel Williams is presiding, and Professor Jeremy Kidd will be the moderator of this panel.
Jennifer, can I just
yes.
one thing? I think it was, it's up to the individual panels whether they want to use cards or whether they want to take the questions from the audience.
Yes. Professor Kidd.
I think well, my normal preference would be to take them from the audience, but I think it'll be easier to get it on audio.
Fine, whatever you want to do.
If I read them.
It sounds different.
Yeah.
So just have to excuse me if I can't read your handwriting. I can barely read my own.
Thank you. Professor Kidd.
Well, welcome everyone to our panel number 4, Globalization and Impact on Global Supply Chain Solutions. That's a bit of a mouthful. I have a PhD in economics, and I'm not entirely sure what we're in for this afternoon, but I have met all 3 of our panelists. They all appear very smart, and I'm actually very excited to hear what they have to say. We will first hear from Todd Benson, who's the Assistant General Counsel for International Trade for the United Parcel Service. We also have David Stepp, who's a partner with Brian Cave, and Eric Chaffee, who is a professor of law at the University of Toledo College of Law. I am Professor Jeremy Kidd. I'm an assistant professor of law here at Mercer Law School. Without further ado, we will turn it over to our panel discussants in that order. I will point out that, I said without further ado, and then I keep talking. I will point out that each panel discussant is limited to 15 minutes. They will have notes, and I just point this out because I have actually been given instructions for once in my life to interrupt, to be rude and interrupt if they go over 16 minutes. So they have 15. If they go past 16, I do get to interrupt. I'm not encouraging it, but I am kind of looking forward to it being the one time where my mom would not get angry at me for interrupting. So, without further ado.
Well, it's good to be with all of you. I've really enjoyed the presentations that have gone before. And thank you to Mercer for putting together such a wonderful program. It's been very impressive to me to see how well it's been put together and organized. And Jennifer and your team, nice job. And also Joel for inviting me to participate. I've really enjoyed the involvement. I work at UPS, as you heard, and we operate in 220 different countries around the world. We provide small package delivery services that you're probably familiar with. We also provide logistics services, a variety of different modes and logistics throughout the world as well. And so we're sort of right in the middle of that bowl of spaghetti you saw earlier. Since we're just past lunchtime, I thought I would mention that food analogy. We're sort of we're in the midst of, that was just the agreements that you see, that you saw portrayed on the screen there. But in our business, we imagine we're sort of in the interstices between all of the spaghetti. We deal in all those different countries in many different modes of transportation, many different types of logistics, engaging with governments in different ways, all throughout, importing and exporting from all of those different countries. So it's a fascinating space to be in. And so I wanted to share some perspectives with you, what we see and what we at UPS think we ought to be seeing in I think what was referred to as a just legal order. Professor Linarelli mentioned that. So let's see if I can figure out how this works. Now, before getting into some of the issues that impact the global supply chain, it's important to have an understanding of some of the directional trends of customs and other border agencies. These are what Professor Linarelli referred to as the mandatory and coercive institutions that have been created, in this case, to monitor and control trade. So we deal with particularly customs administrations. Some of these are more than projected trends, I might add. All of these items mentioned here on the screen already exist and continue to gain global momentum. So we are seeing efforts to require advanced shipment information earlier in export and import processes. We see greater focus on compliance of products, for example, intellectual property rights and consumer product safety. We see development of security-related screening systems, such as air cargo advanced screening, which I'll briefly address later. We're seeing the early stages of trusted trader programs and authorized economic operator types of programs. We're also seeing an increased focus on export and export procedures. Now, the standards vary in different countries. In the case of exports, it's really customs authorities looking at export declarations, looking to see that nothing is out of sync. Just mentioned, in addition to some of these global trends that we see, there are a number of regional variances that are worth paying some attention to. Some of these, I'll just highlight. We've heard a little bit about intellectual property rights in Europe. Data accuracy. This is a fairly sophisticated place to do business, very advanced system, whereas in Latin America, they're focused on some of the more rudimentary aspects of trade regulation, basic risk assessment, and duty collection. So those are some differences that we see in the regions. Now, there have been many economic studies done, of course, and the one that we tend to rely on is one that is developed in the private sphere, the World Economic Forum, and similar to what has been expressed by others, we are strongly of the belief that more trade equals more investment, more growth. I think Professor Cohen mentioned this, and more development. The cost of trading across barriers is estimated by some studies at $2 trillion. Removing half of all trade barriers, such as costly border and customs procedures, could stimulate the global economy by more than $1 trillion. That's Pascal Lamy. We heard, well, I'll just continue. Improving trade facilitation indicators could lead to a 14.5% reduction of total trade costs for low-income countries, 15.5% for lower middle-income countries, and 13.2% for upper and middle-income countries. And of course, consumers benefit when costs are lowered. Reducing barriers to trade and supply chains could increase GDP 6 times, as much as eliminating tariffs. Global GDP could increase 2.6 trillion, 4.7%, exports 1.6 trillion, to 14.5%. There's a potential to create 137 million jobs, according to the World Economic Forum. But you can see the great benefits that are enabled as we eliminate trade barriers, as Professor Nadolo so ably pointed out earlier in another area. So global supply chains support international trade. The intermediate goods and services represent 56% and 73%, respectively, of all trade in goods and services, with 30% of all intermediate trade conducted between corporate affiliates. Lowering supply chain costs allows for lower goods and services costs for consumers. So this slide here, it highlights some of the key bottlenecks we see at borders we cross. And there are many borders to cross between 220 different countries. And I'll just point out a couple of them here. One is the de minimis, and then the single window. De minimis has to do with the threshold at which customs agencies will pay attention to an import. And when you have a very low de minimis threshold, there's a lot of time wasted on very small and insignificant shipments. So when you raise that de minimis level, you focus on higher value shipments. It's more efficient for the lower value shipments. Customs wastes less time. This is something we strongly support. The single window idea is where you have one big database for border clearance. There are multiple agencies that are involved with border clearances. In the U.S., we have Customs and Border Protection, we have Fish and Wildlife Services, USDA, Department of Agriculture, Food and Drug Administration. Depending on the shipment, you can have many different agencies that are interested in the contents of a shipment. So having a single window that you can look through, we've made progress with that in the United States. If we can achieve that in other countries, it makes it facilitates trade. Now, while addressing some of the issues impacting the global supply chain, we need to recognize some of the guiding principles that need to be part of any solutions. Just referencing Professor Minardi's talk, these are impartial principles that can be implemented reciprocally. So I'll just mention them. The balance between security and trade facilitation. Countries have legitimate interests in ensuring that goods come into their countries and their borders in a secure fashion. We're not interested in having dangerous goods flying on airplanes, for instance. That's an important objective. At the same time, we do want to find ways to facilitate the efficient movement of goods across borders. The simplification of border regulations and procedures, leveraging automation and technology capabilities. And some of the countries we deal in have very rudimentary systems that will really slow things up to their own detriment, I might add. Harmonization and standardization of programs. To the extent that the rules and the way things are done can be harmonized between countries, that facilitates the movement and the preparation of customs entries and the like to enable goods to move more quickly and efficiently. Reduction of paperwork to support sustainability objectives. That's one of our mantras at UPS, but it's a real issue, and so we support that as well. Growth, service improvement, and cost reduction. These are all mantras that we would state. And all relate to social capabilities and financial capabilities, as Professor Klein mentioned. These go to infrastructure, education, and systems, research and development. There are some good initiatives that were started by the World Bank that we would like to see continued and in other forums. Okay. Next, just to mention, there are some more clearly defined principles that need to be recognized when we're talking about making progress with customs administration. Separation of security and commercial trade compliance. The single window concept, where you have one government at the border that you deal with. Promoting advanced electronic information and review prior to arrival at the border. That can greatly facilitate. Streamline border clearances through automation and account-based processes. Global consistency and substantive mutual recognition of programs. We think these are decent, fair, and reasonable principles that everyone, all countries and all market participants, ought to be able to agree upon, agree with. Now, an example of one of the more important initiatives that customs administrations are really paying attention to. In the case of the U.S., we've got the Global Air Cargo Advanced Screening Programs. This is probably Customs Administration's #1 priority to ensure shipments are safe to put on aircraft. Essentially, you want to understand that there is sufficient screening with minimal impact to the movement of cargo to identify high-risk shipments early in the supply chain through advanced information collection. You can see some of the issues that we look at there. We'd like to be able to look at historical shipping information with a customer. We'd like to have customers that have certification with their governments and other ways to engage in risk assessment. The point of this slide is really to show the separation between security and commercial information from a risk assessment standpoint. This supports the principle that I just mentioned in the case of advanced cargo screening to put a shipment on an airplane from a security standpoint versus completing the commercial part of the transaction at a later time period. Now, if customs administrations or other regulators require all the information on the commercial side in advance of cargo being loaded, it really slows things down. You have significant bottlenecks. And we recognize the need to have appropriate screening for security reasons. But that's a different matter from some of the commercial things that can be done later in the process. So we support efforts to do the security issues up front and find ways to do that in an efficient way, while at the same time finding reasonable ways to enable the commercial side to be done. Another way of looking at this is a continuum of factors that on the left-hand side of the slide here, the security side, most people would agree with. These are more important as it relates to the security of an aircraft and what happens with an aircraft. Whereas on the other side, you have less critical risks, very important still. So because it's less concerning, we see a lot of different initiatives by different customs administrations and regulators to come up with ways to deal with those issues. And that's where so we have a lot of divergences on what needs to be done, which results in trade barriers. Just briefly, it mentioned intellectual property rights. It's important to recognize that counterfeiters follow recognizable business models. Fake goods have an international supply chain. The rights holders, regulators, and enforcement agencies, we believe that they need to focus on the source, whereas sometimes they are focusing on the carrier. Often we have little visibility to the contents of the package. There continues, we continue to see a focus on the destination, which typically only focuses on the smaller players. There's little or no risk to the actual counterfeiter, and really diminishes the return on effort. So just here to mention that solutions that are being put in place by regulators here can end up having unintended consequences or being of little effect at all, but really hindering the flow of commerce. So just highlight those points. I think I'm about out of time, but it's been a pleasure to be with you. And if there are further questions, we'll talk about them later. Thank you.
Hello everyone, we'll get this teed up. I'll introduce myself. I'm David Stepp. I'm out in Los Angeles and Santa Monica in California for my kid. And I'm an international trade, primarily a customs attorney, focusing on traditionally U.S. import laws, but also increasingly global customs issues. Along with that comes all of the global supply chain logistics issues. Very early in my career, I worked for a customs broker. Actually, a customs broker that the U.S. acquired a number of years ago. And with that background, it's been very interesting in my practice as a customs attorney in seeing how supply chains can really dictate how a company sources its goods and meets the market demand. I'm going to talk briefly on the three major areas: free trade agreements, e-commerce, and cargo security. Many of these issues have been discussed in the various panels today, but I'm going to try to share with you some of my experiences as an international trade attorney in these areas. Here's a list of, I think, 20 countries with which the United States has free trade agreements. Quite a long list there. I work primarily, I've worked with probably, I don't know, maybe 15 or 16 of these agreements. As has been noted, even though the WTO, the multilateral trade regime, focuses on things at the WTO level, I think in reality, the bilateral and trilateral and the smaller trade agreements are way the way things are going forward. The TPP has been mentioned, as well as the Transatlantic Trade and Partnership Agreement. The next few slides talk about U.S. priorities in FTA negotiations. Certainly market access for services is a big one in Asia, and primarily in Asia, but also in Latin America and in Europe. I'm going to focus just a moment on market access for goods, because I think that's where a lot of my experience is. Certainly lowering tariffs in the NAFTA, I believe as Joel has pointed out, the tariffs were reduced relatively quickly, I believe over a 7-year period, whereas things were much slower and maybe non-existent in the phase out with the Canadian tariffs. And tariff rate quotas. Rules of origin is an area where I spent quite a bit of time. In fact, I just got an email before this panel started about a rule of origin issue. I was telling one or two of the law students last evening that they asked me how I'd gotten into this area, and I said that I wrote a law school note on a rule of origin issue. And I probably haven't moved very far away from that since. But either I know what I'm talking about or I'm pretty boring. I'm not quite sure what it is. But rules of origin are really crucial for companies in dealing with their supply chain and strategically where they're going to be sourcing their goods. In the early 90s, I had the opportunity and challenge of working at a law firm that represented the Japanese electronics industry. And during the NAFTA negotiations, one of their primary goals was trying to figure out how televisions could be manufactured in Mexico in a way to service the U.S. Market with as much content made in Japan. And so those negotiations went on for several years, and out of that, along with the television rules and some of the other electronics rules, they're incredibly convoluted, probably only surpassed by the textile rules, and perhaps the sugar rules and some agricultural products. But in thinking about the supply chains for manufacturing of goods, in the television situation, before we had flat panels, there was a cathode ray screen and actually a photo mask in the television itself. And the origin of that tube dictated the origin of the finished television. So the Japanese couldn't ship the television tube from Japan into Mexico. They had to actually manufacture the tube there, the picture tube there in Mexico. So what constitutes origin Mexico for a picture tube? Well, there were several parts that had to originate in North America. Interestingly, the glass had to originate in North America, and that was a sticking point because Corning out of New York, which had a huge bank of lobbyists, had very successfully lobbied for the U.S. to insist the glass originate in North America, and it just so happened that Corning was the major supplier of that glass. And so when you look at the NAFTA rule of origin for televisions, which is relatively not applicable today because of the technologies with televisions, but if you look at it, it's because of that glass that the rule of origin is written the way that it is. If you look at other electronic products, it's the PC boards, where those originate. Some of the products specifically require a certain number of PC boards to originate in North America. So when you think about free trade agreements, those rules of origin are negotiated in a way to ensure that the countries are looking after their domestic industries for purposes of politically as well as economically for the countries, and that has a huge impact on the way goods are sourced and manufactured around the world. When I think about the companies and the government entities that I've worked with over the years with respect to rules of origin, I've got the two extremes. One is back in the 90s when I was working with the Japanese, it was all very strategic. You started 10 years out, 5 years out, or they did, in figuring out where they were going to place their factories. And a lot of things went into that, like free trade agreements, rules of origin. They would have a whole team of people assigned to this issue of where they were going to place their factories. And then you had all of these sub-issues like rules of origin and all the various economic issues, people assigned to those sub-issues. You compare that to a situation where I had 5 or so years ago with an Australian company that was manufacturing a product that had a major Chinese component that was shipped from China to Australia. They manufactured the product in Australia and they shipped it into the US. Unfortunately, under the rule of origin, for marking purposes, which also dictates quota in certain situations, the canvas in this case was still originated under the rule of origin in China. So as it turned out, there was a tariff rate quota for that product that came to the US, and it made their product completely unmarketable here in the US from a price standpoint. So they just established a factory that was useless for producing goods for the US market. So you have, different ends of the spectrum there, but I can't stress enough how a lot of the issues that are very technical, that are very political, as we people know, or don't really realize that go into the whole mix for purposes of sourcing goods and supplying the market. Other issues include standards. Intellectual property people have focused on here today. One thing that's really interesting with respect to sourcing goods overseas, I represent a U.S. retailer, and they only have stores here in the U.S., and they do a lot of their production in China. Well, it turns out that, of course, they had their trademarks registered here in the U.S., but they didn't have their trademark registered in China, and they don't sell in China. Well, someone had, and I think this might have been alluded to earlier by the gentleman from UK, but the trademark had been registered in China by another party. And even though they didn't sell there, their goods were being held up at the court because they infringed on that trademark that registered in China. Huge impact with respect to supplying the market here in the US because of intellectual property issues. Agriculture, I won't spend additional time on, just to say that rules of origin can be really important in that situation. I worked with Joel over the past couple of years on a project where sugar is moved across borders and processed in different countries. And the way the rules are for purposes of origin and quota can have a huge impact as to whether the goods can come in under a normal duty rate or one that is elevated significantly. Labor issues, of course, are a big issue, as well as environmental issues. Moving on from the NAFTA example to the more recent free trade agreements like the Korean bilateral agreement, the U.S. has moved beyond side agreements for purposes of labor and environmental standards. And in fact, ILO, International Labour Organization, and international environmental treaties are dictating a lot of those trends now. Political challenges for free trade agreements. I'll just touch on briefly. The Fast Track Authority in Washington, which expired in 2007, is under renegotiation. Certainly any new free trade agreements, such as the TPP, will rely on Fast Track Authority, which allows either an up or down vote in Congress as opposed to endless sorts of amendments that usually kill those types of things. Obviously, the advantages of free trade agreements for U.S. and global companies can be huge. I believe that when you think about platforms for North America or the Americas, and you see where China is having its experiences in negotiations with free trade agreements. If China negotiates a free trade agreement with a South American country that has, in turn, a bilateral agreement with the U.S., that South American country or Latin American country can certainly be a platform for the U.S. market, so it can be very important. E-commerce is an area where I and my colleagues have been working recently, and in thinking about leveling the playing field and creating a lot of global logistics challenges, that is the advent of the internet society and the global marketplace. Companies now, through stores on eBay, Amazon, and companies themselves have been setting up systems where they can sell directly to customers outside of the U.S. and vice versa. Foreign companies can sell to countries, individuals and companies here in the U.S. One of the things that we found in advising companies on e-commerce issues is that the non-tariff barriers that I mentioned earlier can play a huge role in getting goods into the country. We were advising a company as to a US company that had opened or was selling into China. And there was a huge difference in whether the goods were sold by the US company into China, or whether the goods were sold by a related company or a joint venture partner in China directly to the customer in China. In the latter situation, if the goods from the US were sold to the Chinese partner and then sold to the individuals in China, they had to be labeled in accordance with Chinese law. That was Chinese language and various different labeling requirements that differed from the US and European standards, as opposed to being sold directly to the individuals from here, directly here from the US. So those sorts of non-tariff barriers have a huge impact on whether a company can actually sell the goods. And there's a point where, and a lot of companies have reached positions where those non-tariff barriers can certainly hold up the goods coming into the country for purposes of selling them to their customers. Another issue that I've dealt with recently is for packages going into or sales from the U.S. directly into China, the number of resources committed by the various customs services at the ports where the goods are going to be coming in. Certainly something that UPS and DHL and the other couriers and logistics providers are finding as well. But as international trade on the e-commerce level increases, those resources are shifting, or the need for the resources are shifting from perhaps one mode to another mode. And that can certainly hold up goods coming into the market. Intellectual property rights I mentioned before, but that has a huge impact on, I think one issue that comes to mind is gray market goods. Gray market goods are goods that are authentic goods, but they are generally authorized for one market, but maybe have a price differential that makes them attractive in another market. The U.S. has special rules in place with respect to gray market goods. Very briefly, if the trademark owner in the U.S. is related to the foreign trademark owner from where the goods were shipped to the U.S., the U.S. will allow those gray market goods in because it's assumed that the trademark owner could get control over the goods. So intellectual property rights, certainly in e-commerce content and in e-commerce context, is very important. I only have about a minute left, so I'm going to go through these slides very quickly. Cargo security has been discussed a bit before. The Customs Trade Partnership Against Terrorism, the CTPAT program, is one that was put into place after 9/11. No company wants to wake up and see the name of their company on the front page of the Wall Street Journal and the New York Times because there was a weapon of mass destruction in their container. Certainly, Customs wants to focus on the bad actors, and so they're trying to get the good actors involved in cargo security programs such as CTPAT. It covers importers, carriers, logistics providers, port authorities, and foreign manufacturers. Set forth here in this slide are a variety of the steps involved with respect to being a participant in CTPAT. And one other cargo security initiative is in border security filing ISF with setting forth additional our pre-shipment data that has to be transmitted to the customs authorities. With that,
So, my understanding is, Dave, you may have to leave early.
that's right.
Okay.
Well, I have to leave on time.
Oh, well, all right.
Just a minute.
I didn't know. Okay, so.
But I'm happy to take a question now if we have it.
Do you have other questions for Mr. Stepp?
Okay, so, David, please address the issue of customs procedure to prevent knockoffs from entering the U.S. by the IP holders registering their trademarks with customs.
Okay. I'm happy to answer that. You know, the Customs Service is the best police at the border for purposes of protecting a company's trademarks and other intellectual property like copyrights. There's a mechanism where companies with trademarks and copyrights can record their registered intellectual property with the agency. And customs actually have in their database photographs, along with those applications come photographs and descriptions of the goods that are covered by the intellectual property, so that when goods come in, there are customs inspects increasingly a larger number of shipments coming in, a lot of stuff gets through, but they are on the lookout for those goods, and they call the intellectual property right owner when they see goods and they question whether they're really authentic. If something is counterfeit, customs will seize it, forfeit it, and destroy it. So if you have a Rolex watch that weighs a couple of ounces and doesn't have a mechanical movement, those are counterfeits, and those will no doubt be seized and destroyed. There are confusing and similar sorts of marks that maybe are variations on reported trademarks, and then there are other gray market goods. But the Customs Service is very good at enforcing trademarks and copyrights, provided that they're reported. They have the jurisdiction to interdict them and seize them, but certainly if trademark owners and copyright owners report to the customs, that goes a long way. Anything else?
So apologies for that divergence from the normal, and we'll turn it over to Professor Chaffee.
First off, I want to say thank you to all of you for having me. They've been an absolute pleasure to work with. And I do a lot of these conferences, and I can say that they're one of the top groups that I've worked with. Really a pleasure to be here. Mercer Law is one of those institutions, the more I learn about, the more I appreciate it. Meaning some institutions out there, you actually take a hard look at them and they don't have much substance. Mercer's the exact reverse of that. Thanks to Professor Jones, thanks to Dean Simpson for having me. I also want to say thanks to Brian Cade for a couple of reasons. First off, the fact that they've sponsored this symposium along with a number of other people. Plus, they've also made my job easier in a couple of regards. First off, Joel has penned this excellent book that talks a little bit about my topic, which is transnational corruption law, specifically taking a look at the Foreign Corrupt Practices Act. And in addition to that, Evan, who is on the next panel, is going to have a bit to say about things from the practitioner's perspective. So despite the fact that Jeremy may want to cut me off, I'm actually going to get to run longer for other people, which makes me very happy. In terms of my goals, the things on the screen are what I really plan to accomplish with the article that I'm putting together for the event. And it may seem rather basic. Meaning the notion that anti-corruption law is a part of international trade regulation, the fact that there has been a transition from thinking about the Foreign Corrupt Practices Act as a means for thinking about business ethics to thinking about economic efficiency, and then in addition to that, some of the harms and benefits to international trade law in regards to a robust enforcement of anti-corruption law. Rather basic, but at the same time, the Legal Academy hasn't spent the amount of time that it really should be thinking about these issues, which is why it's such a pleasure to be here and hear so many bright people talk about what they're doing in terms of their practices. So what I want to do, I want to talk a little bit about the FCPA and the current international architecture of transnational anti-corruption regulation, talk a little bit about transnational anti-corruption regulation as a component of international trade regulation, move on to the benefits and harms of robust enforcement, and then finally, for the practitioners in the room, the question that I very commonly get when I present on this topic, do you think the FCPA is going to stay hot? You know, is it one of those things where it's the flavor of the day, or is it one of those things where I need to be thinking about it regularly and thinking about it often? In terms of the FCPA and the current international architecture, I'm going to start with the Foreign Corrupt Practices Act. What you have on the board is Section 13b(2) of the Securities and Exchange Act of 1934, and also an example of exactly what not to do with PowerPoint. In terms of thinking about 13b(2)(a), it means that you have to keep accurate books, records, and accounts, and in addition to that, you have to have accurate internal accounting controls. And the reason for this is when the Foreign Corrupt Practices Act was passed in 1977, lots of companies were keeping two sets of books. And this was designed to be the solution of that, meaning that you don't want a fake book that's kept for your shareholders and your auditors, and then the book that includes the bribes. In terms of the heartland of the Foreign Corrupt Practices Act, what you see on the screen is section 30AA of the Securities and Exchange Act of 1934. Basically, what it prohibits is issuers from paying bribes to foreign officials, to foreign political parties, or basically paying money to other people for purposes of paying a bribe. If you're concerned that you may not know the traditional definition of an issuer under federal securities law, I can explain that to you, and I'd be really excited about that. But for the sake of time, there are a couple other provisions of the United States Code that basically make it illegal to pay a bribe to anybody in terms of, well, to pay a transnational bribe, meaning to pay, if somebody in the United States chooses to pay a bribe to somebody, a public official outside the United States. There also is are a robust number of agreements requiring that other nations adopt these laws. Started out in 1996 with the Organization of American States, which is unsurprising because when the United States passed the Foreign Corrupt Practices Act in 1977, it was the first of its kind. We move on to Europe. From there, we see a variety of other international agreements in Europe. And then finally, an interest in Africa, and then we end up with the United Nations Convention Against Corruption. What that means is that we are far, far beyond just simply complying with the Foreign Corrupt Practices Act, meaning if you're interested in global supply chain issues, you have to be worried about what your subsidiaries are doing in foreign countries, meaning anywhere in the world where you have somebody paying a bribe from country A to a public official in country B for purposes of facilitating a transaction, you have a problem. In terms of thinking about this as a component of transnational, thinking about this as a component of international trade regulation, probably by this point it's beyond peradventure. I mean, Jim Reed early in the morning talked about the fact that we need to be thinking about this in regards to what is going on in the global supply chain, and what's going on with our suppliers, and what's going on in regards to exporting goods. In addition to that, despite the fact that most case books on this topic completely ignore the Foreign Corrupt Practices Act and focus strictly on WTO law, anybody who is a competent practitioner in this field, meaning anybody at Brian Cave or any other similar firm, is going to tell you that you have to be concerned about these issues. In regards to the benefits and harms of a robust transnational anti-corruption robust transnational anti-corruption law enforcement and international trade regulation. I'll talk briefly about that. First off, it acknowledges and combats what really is a global problem. Taking a look at the Corruption Perceptions Index, which is compiled by Transparency International, which is a non-governmental entity that tracks corruption. What we see there is that a great deal of the developing world still has a very high perceived level of corruption. This, of course, begs the question, well, how do you know if that perception is real? Well, bless you, the answer to that is really difficult to answer because, strangely enough, if you got a bunch of public officials in this room and asked who was taking bribes, you wouldn't get an accurate answer. But that being said, a lot of the emerging markets and a lot of the countries that we're most concerned about have very high levels of perceived corruption, meaning that if you are talking about the Corruption Perceptions Index, the higher the score, the cleaner the bill of health, the lower the score, the greater the concern of corruption. Meaning at the bottom of this list you see Brazil, China, India, and Russia, the so-called BRIC countries. In addition to that, definitely removing corruption improves the efficiency of international trade and prevents supply chain distortions, meaning that ultimately anytime you have corruption in the supply chain, what it's going to create is additional costs, additional barriers, and they're often unanticipated. And a lot of what we do as attorneys is try and fix problems that are unanticipated, and basically having robust enforcement of anti-corruption law and actually having those barriers removed means that the supply chain should function better. It also supports the rule of law. Anytime that you have public officials, you have to be concerned that they're taking bribes, whether it's in regards to international trade or any sort of issues. In regards to the harm, it actually increases transaction costs and distorts the supply chain, which seems odd because I just said the reverse of that. In terms of thinking about Foreign Corrupt Practices Act enforcement, there are a lot of people paying a lot of money to lawyers for purposes of making sure that they're compliant, which, as somebody who formerly practiced law, I think that's a great thing and a horrible thing at the same time, because if I was practicing law, it'd be great because I'm a client. But at the same time, there is that risk that we're spending too much time thinking about Foreign Corrupt Practices Act enforcement and other transnational bribery statutes when we could be concentrating on other things. In addition to that, one of the things that I commonly hear when I give this presentation is that potentially a robust system of transnational anti-corruption law may actually constitute a form of cultural imperialism. In many countries, there is the belief that facilitating payments are simply the way that people do business, meaning that it's a natural and common part of transacting business to pay some bribes or facilitating payments, as they're sometimes referred to. That being said, having talked to some people from various countries recently, that have a relatively high perceived level of corruption, meaning public officials, I think most of them, at least based on what they were telling me, and I guess I don't really know what they're doing behind closed doors, would have the preference that if they could rid their particular countries of those facilitating payments, they would. In addition to the harms of really fixating on the Foreign Corrupt Practices Act, one of the things that it does is overshadows other sorts of important international trade issues. Meaning that, on my way here, I shared a car with Lynn. We talked a little bit about her practice. And the Foreign Corrupt Practices Act is sort of on the periphery of what makes it into law schools. And a lot of the things that she does, which are very important and would be very useful to somebody who is actually thinking about going into this area, for whatever reason, don't tend to make it into the law school curriculum, which is really genuinely unfortunate. In terms of thinking about the reasons for continued diligence by counsel in fighting transnational corruption, I have a bunch of reasons on the screen. The first of which, the emphasis in the United States on Foreign Corrupt Practices Act enforcement. The notion being that the United States was really a leader in this area and wants to continue to be a leader. We have the creation within the SEC of the Foreign Corrupt Practices Act unit. Anytime that you create a specific body to combat a particular problem, unremarkably enough, because most people like their jobs, they will find a way to find incidences of that problem, even if it requires a substantial amount of data. American exceptionalism going along with that point, the notion is that America is a leader in this particular area, the rest of the world seems to be following, and likely America will want to continue to lead on this particular topic. The development of the global economy, meaning that in 1977, up until sometime probably in the 90s, roughly the FCPA was dormant and not thought about that much. Really, within the past few decades, we've seen the development of a global economy, meaning there's a lot more concern about what's going on transnationally than what there was in the past, which will probably mean that we continue on with enforcement of, well, we'll see more enforcement in regards to transnational issues. We have the maturing of transnational anti-corruption law. A couple of examples of that, the OECD Anti-Bribery Convention that you see on the board, which is basically between all of these party members, most of the first world members, meaning that there's a lot of interest in this amongst the OECD members. And we have some other parties here, of course, that have signed off on the OECD Convention, notably Russia, which if you remember back to my chart of or my perception corruptions index chart, they're one of those countries that has a very high perceived level of corruption. In addition to that, we also have the United Nations Convention Against Corruption. Lots of nations now thinking about this. Both of these agreements and the other transnational agreements that I've talked about really requiring adoption of things that look very similar to the Foreign Corrupt Practices Act, meaning those types of books and records requirements and the prohibitions against transnational bribery. And beyond that, both of these agreements really showing that the world is getting serious about fighting corruption-related issues in a way that may not have been in the past, which is a very good thing for purposes of the rule of law. And then finally, continuing concerns about corruption around the globe. And obviously, the Perceptions Corruption Index, which I showed you, there are quite a few countries that still have real issues regarding corruption, and the United States has made it very clear that they don't want to be contributing to that corruption. Anyway, I think that I will leave it there and open it up to questions. Thanks.
Well, please send your questions down. I think I'm going to stay here and ask, because I have a question for the panel. And I'm an economist, so this is going to sound like economist speak, because it is. But there is, you will hear occasionally some economists discuss the beneficial aspects of bribery and other things that would be prohibited by the Foreign Corrupt Practices Act as a way of potentially avoiding even more harmful restrictions on trade. And so Todd talked about some of the restrictions on trade that they have to go through, and UPS and other businesses are really interested in having those trade barriers be reduced. But the economist will say there's a reason those trade barriers are in place. Those trade barriers are in place because someone in that country benefits from them. Now, it may be that it's a particular industry or particular business, or it may be that the person who benefits from them are the bureaucrats who benefit in some individual way. And so the economist might say, I'm not going to lump all economists in here, but the economist might say, if we don't allow some forms of corruption, some forms of bribery, then everyone is bound by these inefficient rules. And if we have some way to get around them, some forms of corruption allow us to get around those inefficient rules and actually make everybody better off. So in other words, I guess bribery is corruption, but it's an important counter to even less efficient corruption. The corruption that evolves from, rent seeking that occurs at the legislature or whatever form of government that a particular country has. And I suppose this might be primarily directed at Eric, and how do we answer that? I mean, you mentioned the rule of law, but if you were to put up the best rule of law argument against that economic argument, what would it be? And for Todd, and I guess David's going to know, but for Todd, for companies that are having to deal with Foreign Corrupt Practices Act restrictions and those kinds of inefficient rules that hopefully these free trade agreements are attempting to get rid of. You don't have to speak officially for your company, but do you find that argument rings true? Whichever one of you wants to go.
I would, well, first off, I'm a little frightened now. I hang out with some economists based on that analysis. I think even permitting some rent-seeking behavior, which seems to be what you're suggesting, meaning whatever licenses, whatever the export controls are of concern, I still think the worth of having the rule of law, the merits of having the rule of law, far exceed any additional economic efficiency that we're going to get from bribery. So I just think that we start from different places, or I start from a different place than those economists who may be looking simply at efficiency. I think, for want of a better term, and knowing how vague this term is, I think that moral rule of law style behavior is just of greater value to me than having a perfectly efficient system.
And if I might, before we get to Todd, if I might, I don't speak too much about that one, but just to follow on that, if we wanted to put it in terms of not quite so much just in terms of economic efficiency, but economic efficiency does impact the lives of the individuals in that country. And so I think this may go to the cultural imperialism point that you brought up, that if the existence of the previous rent-seeking behavior continues, the restrictions on international trade keep individuals in that country at a much lower standard of living than they might enjoy if some minimal amount of corruption were allowed. That's not just an economic efficiency argument, that's an argument in terms of the actual living standards of individuals. That seems like...
Well, that is an argument in terms of the actual standard of living of people within the country, but my guess is it's most of the benefit of corruption, so officials, meaning that I doubt that that benefit is really going to be trickled down, except in an extraordinary case.
I can just speak to it anecdotally. A few years ago, there were a lot of requests in China for handouts from officials, customs officials, and the like. And as a U.S. company, of course, we have strong procedures in place to prevent or protect against that. And we found that when we just stand our ground, there's many ways we can find to get things done that do not involve corrupt payments. Or other types of gift giving or whatnot that could be perceived as corruption. Additionally, I spent some time, I was based in Brussels a couple of years ago and covered Nigeria. And I actually went there. And we were having a lot of challenges. Our people were being challenged to make payments to customers, which is another form of corruption under local law, and not just officials, police and others. And what we discovered is, and this is an operation that had been in place for a number of years, when we essentially established the position that we do not make these payments, and our people took a similar stand with the people they were dealing with, the requests went away, and actually it made our operation much more efficient. They didn't have to deal with this interference and these requests. So it improved efficiency in that case. And my argument would be when you remove those inefficiencies, you have more trade, you have more movement of activity. You don't have these externalities, if you will, to take an economic term, preventing movement of goods and actual economic activity. So that's a real experience that I argue goes along with what Eric was just saying.
Of course, the economists me would argue with the use of the term externalities, but I understand what and I actually think that's a legitimate point. And in fact, I'll even show you my notes afterwards. I did point out that traditional economic argument does lead to you're going to be a good economist. I always tell my students you have to take it 2-3 steps on. If that's what you're basing your compliance with some minimal amount of corruption in foreign countries on, you've actually created an incentive for more corruption. Right? Because then you've designated that as a potential source of income. Once you create a source of income, people will exploit that source of income. So
that's right, and you have increasing demands, which further hinders progress. Of course, I recognize that I'm speaking from the perspective of UPS, which is a very large organization that has a certain amount of clout that not all organizations might have. But that has been our experience.
But maybe it requires a large corporation like UPS to be the one to say no in order to diminish that potential source of revenue from all sources. Yeah. Maybe we've debunked an economic theory here today, so that would be good. All right, so some questions from the audience. For Todd, as a global logistics company, how does UPS deal with export control? What kind of policies and procedures do you adopt?
Only the best. We work closely with our external legal advisors. We have established a strong customs and trade compliance function that is very much aware of the laws that apply. I will state and admit that it's really a U.S. focused compliance function. We do have compliance functions around the world in the regions, Americas, Europe, and Asia. But what we find is it's really the U.S. who has the strongest focus on export compliance. So it really is the case that the U.S. is leading out, and so that's where we're based in most of our activities there. A lot of our activity is following our customers. We have defense contractors and others who have to follow ITAR and relevant rules governing exports. So we have to work closely with them and make sure that when they're looking at UPS as a brand, as the type of company that is going to be strong on compliance, kind of vendor they can rely upon, that we can give them the types of certifications that they need to satisfy their obligations to the government. So it's very involved, and we have a robust program in place to do that.
I did have a question for me. Wasn't anticipating, but it does point out that another possible economic justification for some minimal forms of corruption is that some bribes might be a form of user fee or service. Which it would seem to me that if you view some bribes as, if they are well established in custom, informally, not technically legally, but you're going to the cultural imperialism argument, that if they are well established and well understood that this is just how you do business, they do seem fairly indistinguishable from a user fee, some sort of established customary fee that we would impose via law. They haven't imposed it formally through the legal processes, but it's been established informally via custom.
The U.S. Foreign Corrupt Practices Act actually enables small facilitation payments along those lines. We're very careful about that because that's a slippery slope. But in some countries, like Indonesia, very small payments, we have come to view very much that way as a user fee. In those cases, in very limited circumstances where we have a defined limit, we keep careful records of those types of fees that are paid. $3 US dollars, $1. In those circumstances, we treat it that way.
Dr. Chaffee, would you have any, or Professor Chaffee, would you have any problems with that analysis?
Well, I'm against cultural imperialism, which is probably unsurprising. No, I don't have any problems with that analysis. For something that is actually firmly entrenched, which is minimal, I don't have as much concern as somebody who basically is making a living by taking bribes. Although, perfectly worldly would do it with that approach.
And if you consider the rule of law on a slightly broader scale, it almost seems like some bribery in that context might actually fit within the rule of law if it were well established in custom.
Yeah.
So if that wouldn't violate your property at all.
Yeah, it's a question of what exactly is law. I think that exactly potentially is.
We have a question for, do you have a PhD? Is it Dr. Chaffee or Professor Chaffee? Professor, okay. I just didn't know. So, Professor Chaffee, please differentiate the pay for ministerial acts versus procedural acts by a foreign government official and how one may be permitted.
I'm not sure that I have a clear response to that. I'm not sure that there's a clear line between the two, and I'm not sure that I'm the person who would be best situated to answer that.
You're the one who wrote it. You may corner him afterward and dig deeper. Question for Todd. How does the UPS handle anti-boycott laws and security for EES in foreign countries? Employees. Oh, okay. Employees in foreign countries.
Thank you. As was noted earlier, the anti-boycott rules in the U.S. anyway are really oriented towards the Israel boycott by the Arab League. And so we're very careful, and we have actually had issues where an invoice went through that contained a reference to no Israeli content for goods, and it was picked up by customs. And we had some issues to deal with there. So we're sensitive to that issue. The real challenge that we have is there are other regimes Canada and others, and this isn't really an anti-boycott issue, this is a sanction issue. But there are sort of conflicts between how the laws in the U.S. are treated versus other countries who may actually, like in Germany, they don't allow any sanctions or prohibitions against doing business with Iran. So that introduces some interesting challenges in how you manage your supply chain if you have a hidden or identified screening process or something like that. So that's a big question.
The Arab countries have anti-boycott laws or anti-boycott laws against Israel, for instance. Does it work both ways?
I actually don't know the answer to that.
The other part is the security. I mean, we were talking earlier about the Latin American countries and what a big issue it is for companies to protect their employees there. Is that a big issue for UPS? Trying to protect your employees, or are they all independent contractors?
We have a mix. Our network is made up of what we call brown companies and also service contractors. And I'll go back to the independent example. We have instances where our package car delivery vehicles would be apprehended by armed gunmen. And in those cases, we do have we have guards that accompany those package cars, and we haven't had that many security issues along those lines. But I will say there is more activity in the global supply chain involving theft of vehicles. It's amazing, actually, how much is going on. We've had abductions here in the U.S. and in other countries. Vehicles will be stopped and large cargoes will be stolen. So we don't typically arm our employees, and we just have to deal with that the best we can.
Thank you.
Okay, so we have a question. I assume it's not specifically mentioned, but I think this is for Todd. How have you handled entry into agency agreements in which the laws of that country prohibit the termination of an agency without large payments, or the appointee is an agent for life? Have you circumvented this agency for life by creation of a subsidiary of the entering company in the country?
That's a great question. We see this in Africa and other places, and what we don't do is we don't enter into agency agreements. We don't have agents. We don't call them agents, and that's for that reason. Under the laws of those countries, it's difficult to terminate an agency. So we do have vendors, we have independent contractors that we maintain with agreements that have conditions, and that's how we do it. I hope that answers the question. Does that answer your question?
We don't have any more questions from the audience as of yet, so I was hoping David would still be here, because I had a thought while he was talking about free trade agreements, and it seems to me that free trade agreements end up being a battle between multinationals who want that additional access to foreign want the access going out and the access coming in for supply chain reasons, and between the domestic firms who want some protection. And so it dawned on me that if you were to take a free trade agreement, or the list of free trade agreements, and see which protections are left standing, you have in effect the Forbes 400 or Forbes 500 list of the most influential domestic companies. Because he was talking about the glass company and all of those countries that are able to maintain their protections in the face of increased encouragement of free trade agreements by multinational corporations who want that access. It seems like you have a list of who's influential in Washington, D.C. and who's not. That was my question. I just thought that was kind of cool.
I'll just comment. We want to facilitate the movement of goods for everyone, large or small. And even in the e-commerce space, they're really, that was mentioned, very interesting initiative, and a real issue for individuals that want to order goods internationally. So they'll order a good online. They receive, they think they paid $50 for it. It arrives there at the destination, and they're presented with a bill for $50 additional in customs duties. And they didn't know about when they ordered it. So there are a lot of efforts to resolve those types of issues. But we want to have a level playing field in the sense that everyone can ship their goods. It makes life better for everyone.
That's a very good question. And there's one that I'm very interested in. For Todd, although I think Eric might have some put on this one official position, but since 2005, direct shipments of wine between states have been a big topic, and requirements imposed on carriers such as UPS. Now there's a push for direct shipments between nations. Does UPS have a position on that?
No position whatsoever.
Don't tell anybody. Almost as much as the rule of law, not quite, but close.
That's a close second on your list of important things. Where would economic efficiency fall? Somewhere below free wine?
Yeah,
Probably moving it to It looks like this may be the last question, and it's again another question for Todd. How do you train in anti-bribery compliance? How deep down the company chain does training go?
That's great. Great question. It goes. We try and drive that training to all levels of our company. We have our code of business conduct, which has a statement from our CEO that's regularly repeated and shared with our employees. So they all have a copy of the code of business conduct. We have electronic training that we drive into our managers with the expectation that they will be training their employees and providing guidance to their employees. We conduct training as a legal department. I was just mentioning my visit to Nigeria. That was a very similar situation where we felt like we needed to go out and address anti-bribery, where we've had acquisitions, where we're integrating new companies, where the old company or the company we acquired may not have had robust anti-bribery training or understanding. We have had very robust efforts to make sure that those obligations are understood when they become part of UPS as company. So we drive it right down to the lowest level, and the expectation is strong and I think well understood that we stand for integrity, and that is the expectation.
Thank you to everyone who came. Thanks to our panelists, Todd, Benson, David Stepp, and Eric Chaffee. I will call that good.